Good morning. The hearing board of the South Coast Air Quality Management District is in session. Today is Thursday, August 24th, 2017. The time is approximately 9:10 a.m. We are meeting in the hearing board room in Diamond Bar. There is one change to the calendar today, and that is Bowerman Power LFG, case number 6088-1, regular variance is off calendar. We have two matters today. One is the hearing board general meeting, and the other is an item on consent calendar, Universal City Studios, case number 4935-15 for short variance. I'm going to call that matter first. And I understand, Senator, you had some concerns about this being on consent.
Yes, and respectfully request that if it's all possible, that it be held. And the reason why I'm saying that, after reading the report last evening, that the petitioner talked about complaints against that activity. Each year they've had a number of complaints, and some of them talked about their health being adversely affected by the fog that was created for the recreational purposes. If it turns out that the lawsuiters could, and they informed the district that about those complaints. Therefore, if they put the district on notice and the district failed to respond in an appropriate manner, and if those people were subsequently filed a lawsuit, then the district would be a defendant, in my view. I would suggest, however, I have no problem with them carrying on that activity, entertainment, each year, but they should perhaps, if they gave too much fog or not enough fog based on the complaints, then they should indemnify the district in the event there is a lawsuit based on health effects. I think, and that's the point that I wanted to raise, see whether or not they were in favor of doing that, because we then willingly did not respond to complaints that the people have raised regarding the adverse effect that it would have on their health. That's just my opinion. So that's the reason why I want to ask them, will they indemnify the district? If they want to carry on, because they talked about they may be using too much fog or not too little fog. They're not controlling it properly. And people, they're titrating the amount of fog they control. And if somebody come back and say, oh, well, we got a health problem, we're going to sue you. And the district was made aware of the fact that there's been a problem each year, and the district failed to take any appropriate action to correct the problem, then you're liable, I think.
You have a right under Rule, under Rule 3E for consent calendar to remove an item from consent. I'm not sure, though, that the issue that you are laying out as the reason why you'd like to remove the item from consent calendar is really a viable issue. The matter that we would be considering as we're not the district, but as the hearing board, is simply a variance from district rules regarding opacity. I cannot imagine any legal link between that and any harm that could befall a particular person who is visiting Universal Studios, since there's no legal link to us allowing the use of that fog machine other than a variance from opacity. But again, I don't want to open it up on the merits too much, but if you want to pull it from consent, I'll just read the rule. It's any time prior to the submission of the case. The case has not been submitted yet. The hearing board shall immediately remove a matter from the consent calendar, either upon written or oral request of respondent or petitioner or any board member, and shall hear the matter on the scheduled hearing date or shall assign the matter to the next available hearing date while fully complying with notice requirements, et cetera.
So therefore, a vote is not required in order to remove it. One person can.
No, you can remove it.
Right, I
I'm
can't
just
remove it.
asking if you really feel it's necessary.
Well, no, I explained why I thought it was necessary because when I read the report about all the complaints, including health, I can anticipate, that's what I'm doing, that some of these crazy lawyers, I'm sorry to say that, some of these attorneys representing the people who are filing a complaint against that industry, and then the industry is going to say, when we notified the district about this problem, are we complicit in contributing to the health problem? If we could be more, they should indemnify us, the district, I think.
You have to remember, for example, the district receives, I don't know the number, but I would imagine thousands of complaints, maybe on a monthly basis. The district will respond as the district's rules are laid out. But in order for the district to act and find, for example, a violation of nuisance or a violation of any other rule or regulation, there is, well, let's talk about nuisance because I think that's what this would be in terms of complaints that are coming in with regard to fog that is being used at Universal Studio. They would have to have a certain number in order to reach a certain level, as we've heard in other cases, in order to then go after Universal for nuisance. And so, I fail to see the link legally, but I'm not in a position to argue that for sure. I just am making sure that this is your choice is to remove it for that
If the
issue.
district is not of the opinion that they need to be indemnified, then I have no problem with that. We have the lawyer sitting right here.
Yeah, but I cannot call on that lawyer.
But that's my concern.
Both parties are not here,
I
so
would
either.
I would pose the question, I would ask them about the number of complaints that have been filed each time they've had this event. And they've notified the district when they've had the complaints. And some of them have been health, relating to health, contributed by the excessive use of fog. And I'm saying, wait a minute, the district been notified, and they fail to take any action to protect the health, safety, and welfare of the individual making the complaint. Then are we in any way liable after having been noticed?
Perhaps what I can do right now is see if there's any member of the public who wishes to address the board on this matter. And if I see none, then I'm going to just make sure, does anyone have available, I'm trying to see, oh, I see. The start date would be in September 8th, I think is the first time they're requesting. So there is a little time. When could this matter be scheduled?
Just so I know, if the attorneys for the district don't care, then I don't care.
Well, again, the attorneys for the district can't appear because Universal City Studios is not appearing either.
I know, I understand.
Right. Okay. Being as there has been a request by a board member to remove this case from the consent calendar and to set a hearing, I'm going to order that a hearing be set in compliance with Hearing Board Rule 3E2. D. And we set that hearing for next Wednesday. Okay, Wednesday, 30th is a conflict. Oh, right. Thank you. For Tuesday, August 29th. For Tuesday, August, wait, am I on the right? Yes, that's next Tuesday. Wait a minute.
28th?
Next Tuesday,
What date is that?
the 29th. Okay, the case is now set. It's been taken off consent, and it is set for Tuesday, August 29th.
Oh, 29th, not 28th. All right.
Did I say 28th?
You said 28th.
I'm sorry.
Scared me.
Thank you. Okay, the other matter, and my fellow board members may like to take a few moments before we start the general meeting. I circulated, but it was this morning, one document for each of the items that is on the hearing board general meeting calendar. I don't have it. Do you have the agenda for the hearing board? Thank you. No, for the hearing board meeting. No, for the hearing board meeting. Okay, we're going to go off the record for 10 minutes till 9:30, so that I can give my fellow board members a moment to both take a look at a proposed script that was circulated this morning for one of the items on the hearing board general meeting agenda, and also the text of AB 1132, which is the other item for discussion this morning. So we are off the record until 9:30. We are back on the record, and we are ready to start our hearing board general meeting for today. We have two agendized items, both of which I will begin the discussion of, and then we will open it up for other business. The first item is the proposed script to advise public regarding providing anonymous testimony. And my fellow board members, you will recall that at the last board meeting, we had a pretty lengthy discussion about the yellow speaker card, what we should, or at the previous few, the yellow speaker card, what the speaker card should or shouldn't say with regard to whether names are optional, what the likely impacts of that might be, and whether, as I had asked our outside legal counsel to look into, whether we're actually required to either take a name or we are prohibited from requiring a name, neither of which is true. So where we're left was the idea that we wanted to give the option, but not necessarily on the speaker card. I think we agreed last time that to say optional under witness name is not exactly, without further explanation, what we want to convey, given the legal or quasi-judicial nature of this board and the fact that we would like to have testimony. We need it to be under oath, and we would like our witnesses to be identified if possible. But we do want to give people an opportunity to address us if they really fear retribution and do not wish to give their name. So what we agreed last time was that I would come back today with a proposed script, which I have done and all of you should have. The first 4 paragraphs of this script really is very loose. That was not, the intention here is not that any legal member of the board or anyone else sitting in for the legal member would read this particular script word for word. Every time we have a hearing and we anticipate a significant number of people from the community will come and testify, we will prepare individual comments which address the community, tell them who we are, tell them the nature of this body as being quasi-judicial, to tell them what that means, that we operate more like a court of law than anything else as background. We also tell them we're independently, we operate independent. I didn't put that in this proposed script because it's not really germane to the issue of their name. And what evidence is the best evidence for them to give. And generally, we will tailor that script, so to speak, based upon whatever the matter is that we're hearing. So if we're hearing an order for abatement, we'll generally talk about whether it's stipulated. If it's not, we'll tell them what the issues are in the case, and we'll ask them, or we'll tell them that the most relevant testimony, which is what I've said here in the 3rd paragraph, but more generally, that you give today will be evidence and facts of which you have firsthand knowledge based on your experiences, or which relate to whatever the proposed order or just the papers that have been put out. So I'd like to hear what everyone has to say, but just to know as background that those first 4 are not really part of the script. So I'm just going to read the part that I think is most relevant, and the other paragraphs give background too. And it's about the speaker card and giving their name under when they come to the podium. So my proposal was the speaker card requests that you give your name. And when you come to testify, I will also ask that you state your name and spell it for the record. You may still address this board even if you choose not to give your name. That is your right. But please keep in mind that members of this board may choose to give less credibility or weight to your testimony if you do not choose to identify yourself for the record. That's my initial proposal, and I don't know if anyone wants to have a discussion about it, and I am very open to thoughts regarding whether that's sufficient whether it's too strongly worded, not strongly worded enough. So if anyone has any thoughts. Mr. Camarena.
Would you remind me as to just how much weight, or talk to us about how much weight we should give to testimony that is where the person does not identify themselves, and perhaps you might also go into, oh, never mind, I'll stop there.
Okay. Let's start with that, because the answer to that is that there is no legal definition of how much weight each board member would give to any witness, and that it would include whether or not the witness chooses to give their name. There were a few thoughts of schools of thought on this, but let me just step back and say the credibility that you give to a witness really is a personal thing based upon their answers to the question, whether you believe that they're speaking with veracity, and that's why it's personal. That's why the script says some members of the board may choose. And the weight that you assign really is based largely is really two things. Number one, the factual nature of what is given. So if somebody is speaking on something that is not relevant to the issues we have to determine, then you're not going to give much weight to that testimony, regardless of whether they say that they're the king of some country. So really, it doesn't matter for that purpose. Really, you're going to be basing it on the testimony they're giving, whether it's relevant, and whether it's very factual. And since they're lay witnesses, generally speaking, which means they're not experts, they're really giving you firsthand knowledge based on their own experiences. And that's how you attribute weight. The other thing is the credibility. And again, whether somebody gives you their name or not, it's up to you to determine whether that affects your feeling of whether they're credible witnesses. Last time we had public input from Ms. Feldman, and her input was very valid, and that was, we require all witnesses, including public witnesses, to take the oath, to promise to tell the truth, the whole truth, and nothing but the truth. And it was her feeling that if someone chooses not to give a name, then the oath doesn't mean much. But then we also heard from Dr. Lerner, and I believe that Dr. Lerner, without quite saying it in these words, and forgive me if I'm paraphrasing you wrong, but Dr. Lerner was very concerned about, which all of us are, I think, but Dr. Lerner voiced his concern that we had heard in some of the hearings that there are people who are very concerned about coming forward and giving their name. And that doesn't make them any less credible of a witness or have any less of an experience that they're testifying to. So you yourself would have to weigh whether the person who comes to this microphone doesn't want to give their name, but maybe gives a good explanation, or gives no explanation, but does take the oath, which does it really, I mean, taking the oath, what does it mean much if they're not giving their name? That's up to you to apply. We're required to make them take the oath because we are required to take testimony under oath. But there is no hard and fast requirement that we take someone's name. And it's a gray area when we talk about the fact that we're so different from other bodies that are under the Brown Act. And generally, if somebody's coming to address the governing board of this agency, then they can talk about whatever they want, and it doesn't have to be germane to the matter before us, and it can be about anything, and they don't have to give their name, and they can just say whatever they want. For us, we are constrained to hear things that are relevant. So I hope that that big, long, babbling response answers the question. Okay. Dr. Lerner.
Going back to Ms. Feldman's comments, going back to Ms. Feldman's comments, I just want to, just for a moment, and it may be boring because you people understand this in far more detail than I do. What is the relevance of not stating your name but taking the oath, or stating your name and taking the oath? Because either way, you can lie. It doesn't matter. You can lie, telling your name and not telling the truth, or not telling your name and lie. So I'm not really sure that there is a direct connect. I think we're more comfortable. What I'm concerned about is privacy, and we have seen people who work in these companies where we are dealing with the problems reluctant to really give their names. And I'm just concerned about, I want people to be able to talk, since we're giving them an opportunity to talk. And the oath is the oath. It doesn't matter whether your name is X or I. It's the oath that counts. And I think we each have to make our judgment looking at that person and the content of what their comments, whether we believe them or not. And I think the name is irrelevant, frankly.
I believe that to be valid, Mr. Camarena.
For a person who declines to give their name, I would be interested in why. One of the reasons might be they work for the company. Would it be inappropriate to ask them why?
It may be, because for the same reason they might not want to give their name, they might not want to give their reason, because that might mark them in some way, identify them in some way, to the same extent that actually giving their name might. I mean, they can choose to, and by choosing to, they may increase the credibility in the minds of those who might feel the credibility is at issue for not giving their name. Senator.
This hearing board collects evidence, and evidence is considered when you testify and you take the oath. That's evidence. If you make a statement, it can be told, in my view, question, that is not evidence, because they didn't do it on the oath. And if you do it on the oath, you have to state your name. You don't have to give your address, your name, rank, and serial number. I think that if they want to make a statement, they can be told they can make a statement. It's not evidence, but you can't unring the bell once the statements are made. They may have, in extreme circumstances, some effect on how we would react to that. But if you know in advance, that is not, in my view, it's not evidence unless it's taken on the oath. Maybe somebody can speak to that.
The oath is not in question. They are required to take the oath before testifying. Right, is that the question?
Oh, I see. They don't mention their name when they take the oath.
No.
Okay.
No, they anonymously raise their right hand, and Ms. Byrd.
I just wanted to say that when someone comes before us, we can really ask any question we want. Whether or not they choose to answer is different, but we do get to ask any question. So even if Mr. Camarena wanted to ask, is there a reason that you don't want to give your name? I mean, he could ask that question. It's up to them to decide whether or not they will answer, but we do get to ask that question, so.
Thank you for that. You are right. You do get to ask any question, and they can just decline to answer. We can't require that they answer it, but they can decline to answer it. Dr. Lerner?
Going to that, I mean, we're really sort of going down a narrower channel. They need to know that when they present their evidence in that 3-minute period and they're asked questions by us or the attorneys for both sides, that they have a right not to answer the question. In other words, they're standing there and they make a statement, they finish their statement, and you ask, have any questions for the witness, have any questions to the witness. Somebody may ask a question that person, because they've never been in this situation, they don't know that they don't have to answer the question, because that may put them in jeopardy. What I'm concerned about is their privacy.
But again, we have to look at this through the lens of, there is no hard and fast requirement anywhere that we allow people to address us and that they don't have to give their name. There is nothing. They can't, the closest requirement is that we cannot, as a prerequisite to anyone coming and joining this public meeting and observing this public meeting, we don't have to require them to put their name on a list before they come in. They don't have to identify themselves to come in here. But when it's time for them to serve as a witness, and they're making that choice to come up here and serve as a witness, that's at the time where we have to do what we have to do as a court of law. So we have to administer the oath, a court of law, a quasi-judicial body. We have to take it under oath because, as the senator was stating, otherwise it isn't evidence. And we can't just take public comment because that's not our function. Our function is to hear matters and to take evidence in certain matters. And the question is, we have decided as a board that I think we feel comfortable with allowing, in that rare instance where someone feels threatened for whatever reason, to just refrain from giving their name. And so the point today is merely to come up with something that we might say, since we don't really want to indicate that on the card, because that might have a backlash we don't want, which is nobody puts their name down. And then where are we left? We're left without a lot of really good evidence. So I don't think we have to go into becoming counsel for anybody or explaining to people that they're not required to answer. If the person who's asking the question can themselves say, you don't have to answer this, but it's important to me to know, why is it that you're refusing to give your name? And then they can answer or not answer. But I don't think we want to get into the business of becoming attorneys or counsel for every public witness who comes and testifies before us. I think that blurs the distinction. Would it be helpful to, go ahead. No, go ahead.
Okay, I guess I'm missing the point. We have a member of the public who testifies without giving a name. The comments appear to be relevant, blah, blah, blah. And let's say the opposing attorney wants to ask them a question. They don't want to answer that question because it might jeopardize them in some way that we don't know. They need to know that they're not required to answer any question.
We are on a very different issue now. This is very different.
I
We're
feel
only
like
talking about whether a name is required or not on a hearing board card and to testify, and how we want to address that. But like I said, where you're going right now is a completely different issue, where you're asking us to serve as counsel for every public witness that comes before us and to tell everyone, you don't have to answer that question. That is a job for personal attorneys. That's not a job for this public hearing board. This independent hearing board, we're here simply to allow, if it's not a proper question because there's some legal objection that can be made to that question, then that it can be addressed through that. But if it's a proper question that can be asked of a witness, then it's not up to us to advise witnesses to answer or not answer questions. The only way we ever advise people is, if you don't know the answer, don't answer it. Ms. Bird, Mr. Camarena, sorry. No, Ms. Bird.
I guess for me, the question that initially came up that has been answered now by outside counsel was that there is no basis for requiring or not requiring a name to testify. And if that is the case, then what you have here is generic enough, I think, to address the issue of someone not wanting to give their name. And that's all we were trying to get to. And for me, and I know I'm sometimes very simplistic, for me, this would be sufficient. You're telling them why this is the card that says that you give your name. You don't have to give your name. It's your right. And what will happen if you don't give your name. So it explains it. It explains, you're right, and it explains the consequence of your action. So I think at least as a start, we may find something as time goes by that might need to be tweaked. But I think what you have here as a start is a good start because it covers the things that we were concerned about. At least covers what I was concerned about when I first started looking at this card.
And let me ask him, because Dr. Lerner, I know you have some hesitations. Do you have hesitations about that paragraph and what is stated in it, based on the way it was framed just now by Ms. Bird, in terms of this is merely that we've made that decision. We do want to give people the right, but we want to let them know that some members, and not all, may choose.
Ms. Bird's comment is straightforward and right to the point. We're only dealing with this issue. But the argument that I'm presenting about the right to refuse to answer a question, these people don't know. These people don't know that they don't even have to give their name when they come up here. We're informing of that. You also, and I don't think we're acting as counsel for, and maybe we are acting as counsel for these people. They're not being represented. This is a public meeting. This is a public hearing. We should inform them that they may be asked questions as a matter of course. They are not required to answer them if they're, for whatever reason that they want. I think it's important, and I don't think there's anything more than that. I know this is going beyond the scope of what we're doing, and I've often gone beyond the scope of what we're doing, but to answer your question specifically, the last paragraph is perfectly fine with me. I have no problem with it.
I just want to start by saying I actually disagree with what you're saying. If a person is choosing on their own to present evidence to this hearing board, they do not have a right to present that evidence in a one-sided nature and then to refuse to answer questions on cross-examination by opposing counsel. I'm trying to find the, so that I can read it to you. But we are required to give all parties the right to cross-examine all witnesses. So for us to advise, again, it is not our job to advise people who come here what to answer, what not to answer. That's a whole different question, and again, one that we should not step into that role. But it would be incorrect to tell someone who affirmatively is giving evidence that they are not required to answer questions that are relevant to the testimony that they just gave. I don't know, Mr. Camarena, did you have something you wanted to add? I see it.
Yes, Dr. Lerner's concern makes sense to me. We have individuals who come here, perhaps the first time they've ever been in a public meeting, and they don't know that they don't have to answer. They don't know they don't have to give their name. We're telling them that they don't have to give their name, so that's a form of illegal advice. It does make sense to me.
Are you saying that we should counsel everyone? We should have a discussion? First of all, that's not what's agendized for today, so we'd have to put it on the next hearing board meeting. Are you saying that this board would like to have a discussion about how to counsel public witnesses as they come before us? Because let me just step back and say, I'm not looking at this as counseling any witness. I'm letting them know as the actual body from which they're appearing before that we believe that under the Brown Act, they can address us, whether they give us their name or not. And that is our gray interpretation of the Brown Act, essentially, is what we're telling them. We're not advising them anyway, and we're not getting into what they can and can't answer. We're merely telling them that they can address us without identifying themselves. But I think that's different from the content of what they're testifying to. But with that said, I think we're going into an area we should stop. Would Dr. Lerner, would Mr. Camarena, would you like to agendize that for the next hearing board general meeting? Yes?
Likewise.
And let me, is there's a member of the public perhaps who wants to weigh in? I didn't know if anyone, okay,
I have a word
yes.
preference. I don't know if it's good English or not, but it seems to flow a little smoother for me. The last sentence says, but please keep in mind that members of the board may choose to give less credibility or weight to your testimony if you do not choose to identify yourself. It would seem to me to flow smoother if the last few words say, if you choose not to identify yourself for the record.
That sounds good to me. Does anyone else, did you have any other?
No.
Okay. Does anyone else have any comments on the wording,
Yeah, right.
Senator?
The first paragraph is appropriate as it is. The first paragraph?
Yes, but just before you make your comments, just know that the first 4 paragraphs is just an idea. It's not really part of the script, but it's the basic ideas that should be conveyed for background
I understand.
to anyone testifying.
But I'm saying, when you introduce the first paragraph, then you can talk about whether they want to give the name and speak or not. And I would say that in the last paragraph, where you say the speaker card is requested, it gives, et cetera, the word in the second sentence, you may still, I think we should strike still. Because the first sentence is appropriate.
Oh, you may, okay,
Yeah.
so wait, how would you like it to read?
Strike still. You may address this board even if you
Okay.
choose not to give your name. You know, still.
I accept that change. I think
And then I
that's a
would
good
say
point.
that make this the second paragraph rather than the fourth paragraph.
Again, the reason why is because, just for background, I want to lay the foundation for why. Otherwise, it could sound harsh just to say, we're not going to consider you, we may not consider you as credible, or before you give the background of, we are a quasi-judicial body, we operate more like a court of law, we must hear and consider only relevant evidence and testimony. So that kind of thing sets the stage for explaining that last paragraph.
But the first paragraph talk about speaking, not about the structure of this organization. And since you're on the speaking subject initially, then let that become the second paragraph. And then when you give your comments today,
I think that's fine.
I think that would be, and strike still and you're right on target.
Okay. So in other words, that gives it really makes it stand out a little bit more, and that's the salient issue that we really want them to take from it. That makes sense to me. Anyone else have any thoughts on the wording or? Okay. Then with that, I suppose
Vote for it.
I'm gonna make a motion, I guess. I move that we adopt the script, but particularly the last paragraph of the script, as it word for word, as it applies to members of the public giving their name or not giving their name when they choose to address this board, and that the legal member of the board will make this statement before each hearing, before calling public comment. Is there a second?
Second.
Okay, Senator seconds. Any discussion on that?
I was just thinking that maybe we could put this in our hearing board manual in some kind of attachment or some kind of appendix or something to allow for it to be here in the event that the chair is not here and someone else is chairing the meeting.
That is a great idea, and so my motion will be to add it in some fashion to our handbook, and also so that when these board members are no longer here, it still remains. It still remains.
No longer here, it's still valid.
It's still valid. But I do think that it's for the legal member to state, not necessarily the chair. Does that agree? Do you agree on that?
to an extent, if the legal member is not here and there's an alternate, I would prefer personally that a regular member do the talking on that.
Okay, then we'll just have this script, make sure that it's read, and it will be read by whomever, whether it's the chair, vice chair, legal member. Mr. Camarena, did you have a?
Pardon?
Oh, I thought I saw your hand towards,
Just
okay.
think, oh,
Okay, is there any other discussion on that? Okay, Mr. Camarena, how do you vote on that?
Finally.
yes.
Ms. Byrd, how do you vote on that?
Yes.
Dr. Lerner, how do you vote on that? Okay, passes 5-0. So that change will be made, or that addition will be made. Okay, the second item on our agenda for today is I just wanted to bring to the attention of this board the language of AB 1132, so that the board is fully aware of our involvement in this new law, which does not take effect, I believe, until January of next year. However, I wanted to raise it now because hopefully you've all had a chance to look at it and to see where it is that we come into play. There are two issues that I think, that must be resolved before this law takes effect, because we need to hit the ground running if called upon to do so. The first issue that I saw, which we don't have an answer to yet, but I just want to put it out there so that we're all aware of it, is in the actual text of the bill, so beginning with section 1, and I guess it's 42451.5, and it would be C. Number 1 is the timing. So let me just read it. Upon receipt by the district of a notice of defense to the accusation from the person, and let me just define all those things, paraphrase, define. The person, it's obviously the facility, which the executive officer. So just as background, this legislation allows the executive officer to essentially do emergency orders for abatement. The person is the facility, the accusation is the actual statement of, it's defined in here, but the statement that's given by the executive officer. And then the notice of defense is what the facility would file in response. So upon receipt, the district then has 3 business days to set the matter for a hearing pursuant to this article. And later goes on to say that hearing would be by the hearing board. This is the troubling part, not troubling, but the part that we really need to decipher. It says, which shall be held and completed as soon as possible, but not later, sorry, it's small for my eyes, but not later than 30 days after the receipt of the notice. Our rules, or not our rules, the Health and Safety Code requires for orders for abatement that there be 30-day published notice, and that given what needs to be done by the clerk's office, et cetera, that takes 45. Am I wrong? Oh, my. Okay, that's not an issue then.
Yes, we usually allow 20 days total. We allow 10 for prepping. And
Thank you
getting
for
it to the
that.
Newspaper, and then 10 for 10 public.
Perhaps I should have looked at that before I went. Okay, so that won't change. The other issue, my bad, the other issue, we need to come up with guidelines, because when we do have the hearing, we need to, there's all, the executive officer can pull this emergency order for abatement, I'm not sure what it's called, at any time, that they no longer find a substantial evidence that there's imminent and substantial endangerment. For us to continue that sort of interim, we'll call it, order for abatement, we need to make a finding that finding needs to be a determination that there is substantial evidence that an imminent and substantial endangerment to the public health or welfare or the environment still exists. So that determination would need to be made, and if the hearing is not completed within the 30 days, then we would still need to make that finding within the 30 days. Also in provision, and that is also in provision subsection C. In subsection F, the hearing board has the right to vacate that interim order at any time after a hearing is commenced if we find that an imminent and substantial endangerment to the public health or welfare of the environment no longer exists. So there are two opportunities for us to either make the finding that it exists or to not make that finding. And since this is something new, it's not good cause, it isn't similar to the findings that we would make for an emergency or an interim variance, we will need to come up with some form of guidelines. I don't think they need to be extensive, given what I see. So I'm going to give you a little bit of background. I asked our outside counsel to look into whether this phrase is used elsewhere, and if so, whether it has been defined elsewhere, either by case law or by any kind of guidance. And it is used elsewhere in the Health and Safety Code, but it hasn't been defined by state case law.
I think I lost you. Which phrase?
The phrase imminent and substantial endangerment. We can determine whether there's substantial evidence. That's just a matter of whether we've received sufficient evidence to make the finding. But the finding that we need to make is imminent and substantial endangerment. But according to our outside counsel, imminent and substantial endangerment has been defined in federal case law. And in particular, that exact phrase is used in the Resource Conservation and Recovery Act, RCRA. And I won't read the whole thing, but essentially it allows a private right of civil action to anyone who can offer proof of something that may present a, quote, imminent and substantial endangerment to the health or environment, to health or the environment. There is a case, a U.S. Supreme Court case, which further defined both the words imminent and substantial. The word imminent was further defined using, apparently, Webster's dictionary, as something that threatens to occur immediately. And they further elaborated that that language implies that there must be a threat which is present now, although the impact of the threat may not be felt until later. So, and further, a different court, a federal court in the District of Wyoming, further elucidated that factors giving rise to it are present, even though the harm may not be realized for years. And of course, we deal with issues like that all the time, where something may come to us and there are emissions of a particular toxin. That's occurring now. It may present a threat 30 years from now over exposure to nearby residents. That is an imminent. What I'm seeing in the court law, in the law as defined by the Supreme Court and other federal courts, that is imminent. In terms of substantial, it's been defined by federal courts, not the Supreme Court. If there is some reasonable cause for concern that someone or something may be exposed to risk or harm by a release or threatened release of a hazardous substance if remedial action is not taken. So further defined to mean that the plaintiff, again, this is under this RCRA, which grants a private right of action, which means that a private citizen can bring an action if they make those if they meet those threshold requirements. And that person was not required to show actual harm or to quantify the threat of danger. It was sufficient to demonstrate a reasonable cause for concern for the integrity of public health or the environment. But there is no imminent and substantial endangerment if the risk of harm is remote in time, which it seems to me means, when you take all of this together, not that the harm itself manifests later on in time, but that the emissions or the actual cause for the harm. If it's speculative in nature, or if it's de minimis, which is a legal Latin term, which means essentially, yeah, maybe there's harm, but maybe it's of a runny nose or something of that nature. So I know that's a lot because I'm kind of reading it to you. What section is RCRA?
What section specifically
Of RCRA?
RCRA are you referring to?
It is 42 U.S. Code 6921. Wait, no, it's 42 U.S. Code 6972 subdivision A.
6972 subdivision A.
42 U.S. Code subdivision, I'm sorry, 42 U.S. Code section 6972 subdivision A.
Thank you.
And again, I know this is a lot, but I really, the point I just got, by the way, I just got, just so we know, that I'm not withholding anything, but I just got this memo yesterday, late in the day. So I had asked our outside counsel, Mr. Strumwasser, to put this together. And originally we were shooting for Tuesday so that I would be able to be a little more prepared as to how we would define these terms. But the point, I think, today is to let everyone know that we are going to need to adopt guidelines and that there is guidance that does exist. And that I think if everyone agrees, this federal law would be a good starting point for this hearing board to start defining both the words imminent and the words substantial when it comes to endangerment of the public. Mr. Camarena.
One of the hazards of not being an attorney is that sometimes seem to be very simple. The Health and Safety Code has a number of words, 41700. The nuisance law is really vague. And the district has adopted guidelines for the issuance of notices of violation wherein the district alleges a violation. But when it comes to us, usually in an order for abatement, and we see a number of notices of violation issued, it's up to us to decide whether or not a violation has occurred if it's not a stipulated order. And we decide if it's a violation of 41700. Not based on the number of complaints, at least I don't, but on the nature, the detail, the severity, the length of time, the frequency, all of those things come into play. And so when I think about that, and I think about imminent and substantial endangerment, when I first read this bill, I thought, okay, these are two separate things. Is it imminent? I'm going to have to decide for myself if it's imminent. And separately, is it a substantial endangerment? Again, very subjective. I think establishing guidelines will be useful, but I think ultimately it'll be up to each of us to decide whether the matter is, whether the issue is one that is imminent and whether there is a substantial endangerment, and these two are separate determinations.
I agree. Ultimately, it is up to each board member to make that decision. But just as we have guidelines for good cause findings, just as we have guidelines for, if we're going to, we just recently for continuances, what are we going to consider? What are the factors we look at? And the reason why I think it's important that we adopt guidelines is not so we constrain ourselves. And if that sounded like my intention, it definitely was not. I do not wish for this board, unless anyone disagrees, to adopt findings that must be made. Rather, guidelines so that we are consistent, because we want to make sure that what's imminent and substantial endangerment in one case, we're applying the same types of factors, whether we apply it differently because the facts are always going to be different. That is always our ultimate discretion, absolutely. But I think we want to, and having now seen, what guidance there is out there, there isn't a lot. So I don't think they have to be extensive guidelines by any means. Certainly not extensive like our emergency variance guidelines or interim variance guidelines. That's a whole different issue, and that's without notice to the public, et cetera. And those findings are needed to be as sort of stringent and spelled out as they are. But this would be very loose factors that we consider so that the public, and mostly the regulated public, understands that we are not just kind of shooting in the dark every time someone comes before us, but that we know precisely what we're looking at and what we're considering in each case, so that we end up being as consistent as possible, was really the thought. I don't know if there are any thoughts. Really, this is just the general discussion, really, to open up, and then we'll come up with a process from there. So, Dr. Lerner.
My experience on Mondays and Fridays and the rest of the week as a physician, we are beset by guidelines throughout medicine. The problem is the guidelines become analogous over time, like findings of fact for variances, et cetera. And I must caution you about the fact that guidelines, as they will be crafted here, have to have a looseness to them so that there really are guidelines. Because you may have to operate within and without of the guidelines because it doesn't fall in every case, like every patient, doesn't fall into the set of rules. And we're having a huge problem in medicine with this. And there's huge legal ramifications because the guidelines obviously are being interpreted by lawyers as being the rules of the game. They're not rules of the game. So I would encourage you, when you really mean guidelines, you really want to mean guidelines, because over time, those guidelines applied over and over again become sort of a force of their own, and they sort of constrict you, and they don't allow you to think, so to speak, mixing metaphors, thinking a little bit out of the box. I just warn you because I've been around for 50 years in medicine, and I've seen what's happening. And something called clinical judgment and common sense are out the window. If it doesn't fall into these little guidelines, it's not good.
Mr. Camarena.
Here again, I agree with Dr. Lerner. And I think the chair reminded us recently when we were looking at a interim variance petition, and I think I was the one that was taking a very hard line that this didn't fit the guidelines. And I was reminded that these are guidelines, not hard and fast. So I think to address the doctor's concern, and now my concern, is to include at the beginning a preamble clearly stating these are guidelines, not hard and fast, and that the hearing board will use its discretion in considering these guidelines.
Excellent suggestions, Ms. Byrd.
And I think that at that particular hearing, we made reference to our guidance, and our guidance does have that at the beginning of the paragraph, actually. It says, assess the diligence, and then it got into it is not possible to establish a bright line definition. And so I think that being in the first paragraph of the guidance for our emergency and interim findings, it probably should be continued to any guidance that we develop, just to let you know that this is not the only way that it's done. It's just some examples of what could be done.
Yeah, that particular line is buried in the guidance.
Let's put it at the beginning, first sentence.
Well, and again, it won't get as lost because I don't envision, it sounds like the rest of the board members do not envision very lengthy guidance at all. But merely, again, you know, we are used to hearing cases, orders for abatement, and if they're contested, which I think in this situation they'll probably always be contested because it's before a hearing. But when they're contested, we do need to make those findings, right? We're used to the findings of a violation, and we're used to the findings of, well, good cause. And here it's just a step up, and something a little bit more, sort of along the lines of an emergency variance or something where there's just that much more urgency. And so I think, and maybe guidelines is not, maybe just some statement on it with the factors that we may consider based upon what federal courts have seen. Mr. Cameron, did you?
No, I
Oh,
was just
okay. You had
agreeing with you.
Okay. Anyone else have anything that they want to, before we talk about, or go to the public? Senator, yes.
During my training session, I brought this bill to the attention of the board. I had a copy of it before it cleared the legislature. Yeah, and I said that I did it for the purpose, if you had any concerns, you had a chance to share that with the executive officer, and then the executive officer would cause the bill to be amended to meet whatever you think your decision might be. I might say, sadly enough, it was pretty much ignored because due to a lack of understanding, I would say. But let me just say this, and G of this section, it says that air pollution control officer shall not delegate the authority provided by this section. If the air pollution control officer is unavailable or absent, you can read that part for yourself. Then you go and you look at, I'm working back from bottom to the top. The air pollution control officer shall rescind an interim order if he or she finds that the order is no longer necessary. How can that officer find it is not necessary unless they begin to negotiate with the person that they've accused? That means he's preempting. We didn't get to us yet.
We're not required, that's,
That's right. That's before he gets to us.
or after, at
Yeah.
any time.
But the point I'm saying is that the executive officer may be doing preempting us or doing some of the work that we should be doing initially. So I'm going to read, that's, you.
Go ahead, I'm listening.
When you look at 41701B, it says, shall be in effect upon the notification of the person of the issue of the order. In notifying the person, the air pollution control officer shall also provide the person with an accusation specifying the grounds on which the order is issued and procedure which the person may challenge the order. And then it goes on to B, You say, before issuing an interim order, the airport control officer shall make reasonable effort to meet and confer with the person regarding the interim, the imminent and substantial danger finding, and make a good faith effort to agree on the stipulated interim order. So what the executive officer is not doing, is doing what we do, like it's stipulated. If they can stipulate it to the executive officer, it can on the interim order between the two of them, then it's not to us yet.
This bill creates something that does not exist.
That's right.
There is no, well, first of all, let me just step back and say, there's nothing that needed to be changed before this became law. We're merely interpreting our role in this legislation, which is now passed. Nothing was ignored and no opportunities missed. But merely now we are in the position, which I think is a good position, because we've seen many cases where this would have been a useful tool of the district. And now we are part of it. But no one is taking, this bill doesn't take any rights from this hearing board. This bill grants a new right to the Air Pollution Control Officer, or the executive officer of this agency, to issue interim orders which did not exist previously under certain circumstances. And yes, part of those circumstances, as now prescribed by the legislature, is to meet and confer with the facility. We merely come into play because that facility then has a right to a hearing. And so this sets up that right and puts forth the standard by which we would make a determination to keep it in place or take it away.
There's a lot of activity on the part of the hearing officer conferring with the person who...
On the part of, you said on the part of the hearing officer, is that what you meant?
I mean, the executive officer.
Okay.
Thank you, sir. Before going through a process, before it's the board gets an opportunity to make a decision whether or not they're going to have a hearing, that process is going to be time-consuming for the executive officer. This is currently, that activity is delegated to the hearing board because, please now let me finish. If you consider the process, when the legal department takes the inspector's point of view, findings, and issue an order of abatement, it doesn't go to the hearing officer, executive officer, it comes directly to us, to my understanding. Does the executive officer delegate it to the hearing board?
That's a different, you're talking about a very different order. We still hear orders for abatement. We hear them through the regular orders for abatement, notification, and procedures. And we still hear them if no one else has an opportunity to hear those cases except the hearing board. This bill is creating something else. This one is creating like an emergency variance, an emergency order for abatement, which is on a separate track, which is why, unfortunately, I was thinking that the notification processes were different, or the amount of the required notification was different, which was my mistake. However, it is confusing because now it's on a dual track.
Right.
So we need to understand how that's going to work, and we need to figure that out. However, it is a dual track. It could be that we hear both. We hear the actual order for abatement at the same time, or in the same series of hearings, or in the same one hearing day if possible, that we also make a determination of imminent and substantial endangerment or no imminent and substantial endangerment, and then that interim order either stays in effect during our hearings or we vacate it. But it's separate from the order for abatement. Order for abatement is an order for abatement. This is an emergency order for abatement, different.
Yeah.
It's on a dual track, just 1 second, Mr. Chairman. It's a double jeopardy that could be offered by the respondent, saying, I'm on one track, I'm on another track. Which one is appropriate for me to take at this point in time?
No, it's this, you mean
If
the
the
district?
executive officer
That's their decision.
consider an interim or abatement order, and we considering the abatement order also, the same individual. Is that what you're saying could happen? Double, it's dual?
No.
Tell me.
It's interim. So it's, usually it would take so many days for it to be noticed and so many days for us to hear it. And then say it's a very contested order for abatement that could drag on for weeks and weeks and weeks. There would be no order in place, possibly for months. That could occur. We had one case, took a lot longer, took a lot of months. And things had to happen in the interim, and we never even reached that point. But in any event, this is a new tool that is legislatively being given to the executive officer, and apparently all pollution control officers in all districts, which will allow an interim to very quickly be put into place, but only until the full order can be heard by the hearing board. So that allows immediate relief for the community and an interim relief, but it's not double jeopardy. It's more like, you can imagine it as the same as if a facility comes to us and says that we have this breakdown, we're gonna need a regular variance, but oh my God, it happened so quickly, we need an interim variance without notice to the public, really quickly, and this is with notice, well, no, it's not.
Read B.
But the hearing is with notice.
Read B. We've got, Ed, you want to read B? What B says?
Mr. Camarena?
Yes, I want to go back to a concern raised by Senator regarding the process. The process, as I envision it, that the executive officer would go through prior to issuing an interim order, is the same process he would go through to petition for an order for abatement. What this does is get the order issued sooner. When the executive officer seeks an order for abatement from this hearing board, typically they meet with the alleged violator, try to work out a stipulated order. That's the same process that he will go through in this new authority that the executive officer has. But it gets you to the point of issuing an order, the executive officer issuing an order, sooner than this hearing board could do. And it bridges the gap. It's a very important bridge between the time that the executive officer decides an order is needed and the time that this board can notice a hearing, hold a hearing, and come to a decision.
The executive order officer does not have the authority to issue an abatement order instantaneously at the very beginning. You got to go through a process. You look at B, it said before issuing an interim order, read it.
Yeah.
The air pollution control officer shall make reasonable effort to meet and confer with the person regarding the imminent potential danger. So that's a process that we've been doing, but he's got to do that first.
He does it first
Yeah,
anyway.
read it.
Perhaps we should hear from someone from district council.
B is very clear. Pardon?
This is just faster.
Um, Well, we can ask if any member of the public would like to be heard, and if not, that's fine too, but if Ms. Feldman would like to be heard.
You can't change it, it's already the law, but I'm just saying whatever.
Absolutely, right.
Good morning. Yeah, there are several issues that I'd like to address, just very briefly. First of all, please be assured that we are working on formal procedures to implement this legislation. Thankfully, we do have until January to get that all in place. But yeah, we will have a process. Secondly, regarding the guidance that is available for use in determining what is an imminent and substantial endangerment, we are relying on EPA guidelines. They're very old, from the 80s, I believe. And there is case law pursuant to the Clean Air Act that does refer to the kind of risk that we would be talking about under this. That being said, keep in mind that if and when this authority is exercised by the executive officer is the one who has to make the first determination that there has been an imminent and substantial endangerment to the public. So in bringing the matter to the hearing board, the executive officer should certainly be prepared to tell you, district counsel representing the executive officer, how that determination was made. And I would think that in the first case, at least, the hearing board might be asking for written statements from the parties as to whether that standard has been met. As to the concern of the senator about Section B, meet and confer is, I don't want to call it a term of art, but it is a term that appears throughout legal requirements, court rules, discovery rules, throughout the legal process.
Understood.
It is not a hearing. It is not a time-consuming public process. It is simply a meeting between parties. It could even be over the phone. It is just to ensure that before the executive officer takes any action to effectively shut down a business, he's given that business an opportunity to be heard, to offer a defense, and to map out steps going forward, and certainly in a case like this, to determine whether the parties can come to a meeting of the minds on an interim order and what that would look like. The legislation also requires, you'll note in subsection C, that the facility can file its notice of defense as soon as it knows what the executive officer is doing. And then we are under an obligation within 3 business days to make sure that matter is set for a hearing. So this is fast-tracked all along. You can't use the meet and confer requirement to relieve you of your obligation to file for a hearing promptly as soon as the facility says, I'm filing a notice of defense.
Well, I would say to you that I'm a respondent, and I received a notice, and they implement an order, interim order, without going through the process. Telephone call, that won't, in the court of law, that's not going to work. Saying, well, we talked on the phone, we conferred. This is not a lightly situation. If you respondent who think you're being prosecuted or persecuted and you're innocent, I mean, think of the other side.
Senator, they get the right to a hearing, and they get a right to a hearing within 30 days. That's their due process.
I understand that, but
Yeah, nobody's denying them that.
It says what you shall do before you issue the interim order.
Yes, have a meet and confer. All that means is that the facility has to be apprised of what is happening, what the accusation is, give them an opportunity to file a notice of defense if they so choose, and to begin the process to negotiate a
Should
stipulated
they file a
order.
notice of defense with the executive officer, then what happens?
That we have to set it within, a hearing within 3 days.
The executive officer does.
We have to file a petition to get the matter on calendar within 3 days. We have to file within 3 days.
Does it come to the hearing board at that time?
Yes.
So it doesn't stay with the hearing officer, executive officer?
No.
Oh, okay.
May I first say thank you, Ms. Fellman, for coming here,
course.
because my first thought was to have the clerk ask for either the legislative staff or district council to please come and brief us on your understanding of this law as it applies to us. But we were told it was premature, so to do that. And I was concerned that January is going to come up fast on this hearing board, which sometimes is slow to act.
January will, and I am fully prepared to offer at this time to have, to address the board in a general meeting closer to the January implementation date, once we have had an opportunity to review this internally and to start fleshing out the policies and procedures that we will implement to affect this legislation.
Okay, and if there's anything that can be, if this hearing board can hear about any case law or any guidance from the Clean Air Act that exists that has not yet been found by our outside counsel, that would be helpful as well.
Of course.
Dr. Lerner.
We'd make an appeal if this is going in January 1st. There's a tradition in medicine that everything gets crazy starting around Thanksgiving, and the workload goes up and the work product goes down.
Well, here, I don't know if the workload goes up, but certainly staff presence goes down around the holidays.
Yes. So I would hope that the Supreme Court said with all deliberate speed, we could try and get this in somewhere at the end of October, early November, so we would have a better feel, because there'll be a lot of questions as they are here. I'd also like to make one other point. We have that whiteboard over there.
Wait, why'd you turn off your, you turn off your mic.
Sorry. We have the whiteboard over here, and I think it would have been wonderful if we would have diagrammed the process of what we do with a variance, an emergency variance, a brief variance, and then analogously on another column, show what this new law is, because there are overlapping and complementary points of this, and I think we can clear this up, get a better visual idea of what these words mean. And
Yeah, I wouldn't want to analogize this process in any way to a variance process, if only because a variance is filed by an outside party, a petitioner. Orders for abatement are filed by the executive officer. So it's a little different. In terms of clarity for the concern that the senator was raising about these dual tracks, it is a single case. I think if you think of it more like a temporary restraining order or a preliminary injunction that is part and parcel of a larger matter that is filed with the court. It's not a separate case. It's all one case. It will all result, most likely, in one order for abatement. It's just as Ms. Prusak described, that bridge from the start of the harm when it came to the district's attention, and the length of time it takes to get to that final order.
Ms. Feldman, can't be taking it lightly, and I know you're not. But I'm the respondent, and I'm saying that based on the new law, I was not given the hearing that I was entitled to as prescribed by law. Let me tell you what happens. We have time to go through this with a fine-tooth comb and seek out any pitfalls that you might think that the respondent might push back on. There's an opportunity to have technical amendments. They do that all the time up there. Technical amendments to existing legislation so it goes smoothly as it intended to. Please, this is new before us, and therefore, we don't all agree here 100%. I'm looking to see how to make it more perfect.
We may have to actually, I think, experience it in practice before we know exactly how to do that. But the law does provide for the hearing. Nobody's being deprived of a hearing. They're going to get the hearing as quickly as they do now. And at any point, the hearing board can make a determination, as provided in this legislation, that substantial and imminent risk no longer exists and rescind the interim order issued by the executive officer, or the executive officer can make that determination. So there are off-ramps for the respondent. Our concern is that we did not, prior to this legislation, have an ability to effectively address substantial and imminent risk to a community other than the order for abatement. And as this board is well aware, it sometimes takes weeks, if not months, to get that order in place to effectively address the risk.
I'm a respondent, and the executive officer didn't give me sufficient time or an opportunity to defend my position. It wasn't a telephone call. Sufficient time, so therefore I'm pushing back. It's not fair. I'm going to complain about it, and I'm going to take it beyond this interim order. And I'm saying to you that there are some, how much time? He gave me 5 minutes. He gave me 2 minutes. He didn't hear my full case. And the executive officer, based on this, is required to hear it himself.
Senator, may I just stop? Let me just rephrase the issues that are before us. This is one piece of legislation that affects two distinct bodies. Let's remember that this hearing board is independent of the district. This particular piece of legislation, AB 1132, gives rights and obligations to the district's executive officer and separately to this hearing board. So it's the executive officers and the district's job to interpret its own procedures, its own guidance with regard to those parts of this law and those provisions that apply to it. Equally, it is our independent obligation, responsibility to come up with our own guidance and procedures and to interpret 1132 as we see fit. What I'd like to make sure, and that's why with Ms. Feldman here, it's very helpful. I think this board wants to make sure we are harmonized with one another so that we do not adopt a standard that is wholly different from what the district is looking at, and that our processes don't work together. But I don't think it is for this board to advise the executive officer what procedures it needs to do for it to meet and confer, because that particular obligation and that particular responsibility was given by the legislature to the district, not to us. And similarly, we cannot rely wholly on the district's interpretation of what is imminent and substantial endangerment, because that's just one party that comes before us.
Well,
I have a question for Ms. Feldman. Is there not a similar emergency authority in federal law for EPA?
Yes, EPA does have this authority, and in fact, one of the bases for our seeking this legislation is that EPA requires that the district have this commensurate authority. We never did have it, so we are finally addressing that deficiency. DTSC also has similar authority to issue emergency orders.
So the State Department of Toxic
Control
Control
yes. Toxic
has that
substances
authority.
Control. Yes.
EPA requires the Air Quality District to have that.
It's legislation because you brought it before us.
I brought the relevant portions that apply to us before us.
So it's all relevant. And let me say this, that we may be independent, but we're not independent of the legislative process. And what's likely to happen is that when the big fat client feels that he's been denied, and these big oil companies can do that, whatever the case may be, and they're going to go to SCAQMD and start saying, well, we didn't get a fair hearing in that district by the executive officer and subsequently by the hearing board because it's a dual situation. Then you'll have technical amendments. So therefore, I'm saying if there's any opportunity where that's likely to occur, take a look at it now and see whatever you can do to correct it in terms of how you apply it here, not through trial and error as you think it might happen. Say we'll do it for a while, and if we make mistakes, we'll change it. That's not the way to go, I don't think. I'm putting it on the table, do what you like to do with it.
And for the reason why, just to get back to the original issue that I brought before this board, the reason why I was hoping for some we can call them factors for consideration, guidance, loosey-goosey, we can name it anything we want, is for that reason. We don't want challenges to the way that we are applying this, and so we need consistency. So with that, unless there are other, Mr. Camarena?
Are you going to assign someone to propose some guidelines or factors to consider?
I was hoping that we would get started with that. Were you wanting to do that? Is that why? I was going to assign it to myself, but I would happily.
I'd like to work with Ms. Bird on that.
I was going to say, our prior chair, when people had questions and they wanted things to happen, would assign it to that person who brought it up, but
Oh, okay.
Who brought it up?
that's whoever, no, I mean, whoever had the challenge that they wanted or wanted to see something affected, they were the ones who were issued that
was me.
responsibility.
That was me.
No, not this, no, I don't think so, but you can take it if you want. But no, I'm
would love
more
it.
than willing to work with Mr. Camarena.
And also, then, if you would like to take that on, I would also assign to you to use our outside counsel to the extent you see fit, and to let them know that EPA has authority, DTSC has authority. I don't know if it's the same actual language, but that the Clean Air Act guidelines, there are guidelines under the Clean Air Act also, and perhaps those would be most helpful. RCRA we know, and in fact, I'll give you the memo that I got yesterday. So that's where I took that from. Unless there's anything else, I think we will assign to Mr. Camarena and to Vice Chair Byrd to come back at the next general meeting with some ideas for factors for our consideration. Okay, one other matter of business, if there's nothing else on that issue. I just wanted to, given what happened this morning, I wanted to remind all of the board members that it's very difficult for the parties that come before us. It's certainly a burden on facilities that, in a timely manner, request that a matter be put on consent, fill out the papers, do what they need to do, and then all this time, a lot of time to pass, and for a board member to pull it off the day of the hearing. So I would just remind all board members and request that in the future, that we all, if we do want to take a matter off consent, that we please do it as soon as possible. Is there any other matters? Seeing none, we are adjourned for the day. Thank you.